Hi, good morning, everyone. Uh, Thank you so much for joining for this second live webinar for the patent agent exam 2023. Uh, Welcome back again for this second session. We are going to discuss today the hypothetical case studies and how to answer those questions in paper 2 of patent agent examination. uh, uh, like uh, this is an interesting topic because this is something which a lot of students have been asking me again and again. We would be taking some hypothetical cases here today, and we'll try to answer those, as well as I'll give you some hints about how to answer these kind of questions in exam. For those who are joining us for the first time, my name is Vijay Shupuje, and I've been training for the patent agent exam 2023 to the students. And so we also conducted the classes in 2022, wherein more than 60 students qualified the patent agent exam. And these sessions are conducted via live. Some sessions are conducted live via the Pharma Literati YouTube channel, which is now part of the Edu Literati group as such. And we are here for the second session. We had the first session last time, wherein we discussed how 2023 paper would be different from the previous year's papers as such. Therein, we also discussed about 2022 question paper and the uh, end goal actually end goal that actually, or the summary of that, was that we the 2022 paper is generally considered as a practitioner's paper. Those who are just mugging up the things may not be in a position to answer a lot of questions in paper 2 first part, as well as in paper 1 as well. Lot of questions were more for practitioner. Unless you are practicing, unless you are actually in the domain, probably you may not have been in a position to answer those correctly, or unless you're prepared for them. So these are hypothetical case studies kind of questions, wherein uh, a hypothetical situation is created, and again repeating this, that unless you are very sure about unless you are very sure about the concept per se, it may not be possible for you to answer those questions as such in the examination. Now, just an instruction for all those who have joined in for via YouTube Live. You can ask any questions during the session. Would be more than happy to answer those questions. For this particular session. Let me share my screen and start with the session. As I suggested, these are all hypothetical questions as such, and uh, any resemblance is a purely coincidence. Also, try to solve the questions only if you have finished the syllabus at least once. That is, take these questions just as a example, I would say, or take these questions as dummy questions, wherein you can understand what kind of questions are asked in the patent agent exam paper 2. So we are discussing paper 2 part 1, wherein lot of situational based questions are, or hypothetical questions are being asked. I have created some questions. If you have got this opportunity to go through some of my sessions earlier, some of the questions may be a repeat of that as well. Let me start with the first question. And the first question herein is that there are two applicants and inventors. They are named Shahrukh and Kajol. They create an invention which is for an instrument for editing songs. The patent is in hearing stage in India. Ajay, Kajol's husband, suggests improvement in the instrument. Now, Kajol discusses this with Shahrukh, and then so the co-applicant, and then they decide to file another patent for this improved editing instrument. Now Shahrukh and Kajol approach you for patent, filing a patent for this improved editing instrument. Kindly advise them about the course of action and a role of Ajay in this particular situation. Now, herein, if you look at conceptually at this particular question, when you read this question, you should be in a position to understand that the question is basically for a concept which is called as which is used for the improvement of any invention, that is called as patent of addition as such. Now, when you have to answer these kind of questions, um, wherever there are questions like advice or these kind of questions for a client, that point of time, first thing that you do is put it in a letter format. Now, what do you mean by putting it in a letter format? So we have got these examples of letters we used to write to the teacher, to the principal, or to your cousin when we were in school actually, right? So put it in that format to XYZ, or here in the case Shahrukh and Kajol, applicants of this invention. Subject, your query regarding an improved patentability, or your query regarding the patentability of an improved editing instrument. Thereafter, you start with the actual content of your, I would say, letter as such. And in this, how you can actually do that? Remember, there are few things which are very crucial in this particular question that you need to mention, and that is something which you have to mention. See, in these kind of questions, it is not necessary to put the answer in a specific number of pages. What the what the office is, I mean, the patent office is looking at probably is, are you clear about the concepts? And herein, certain terms that are mandatory to answer this kind of question is, I have highlighted here, section number. First important thing in this question is about the concept of patent of addition. If you miss out on the term patent of addition, whatever you write, you're not going to get marks for that. These kind of questions are generally asked for 4 or 5 marks actually. So in this case, it is very essential to put the term patent of addition. If you don't put it, you are definitely going to lose crucial marks. And again, I'm telling you, in paper 2, every mark is really very crucial, because you may not be in a position to attempt all the questions because of the lack of time, as well as because of maybe some questions may actually go, be bouncers basically. So you may not be in a position to answer. So every question matters, every mark matters in paper 2, and therein, if you write the term patent of addition, that is important. Next thing, section number. Now, section number, when we say that point of time, I have a recommendation here, and if you know the exact section number, then only put it. If you don't remember, don't put the wrong section numbers in the answer sheet. If you put wrong section numbers in the answer sheet, you are not going to get rather your marks would be deducted from for that particular question. Third important thing here, look at the kind of question that is asked here. For every small piece you have to answer, kindly advise about the course of action. So the course of action would be, you can file a patent of edition. What are the forms required for the patent of edition? What is the current relevant section number? You also have, and role of Ajay in this regard. Now this role of Ajay is also something which would have certain marks in that. What is the role of Ajay in this case? Ajay, as a concept of patent of edition, Ajay can be an additional inventor. Ajay can never be an applicant, because in case of patent of edition, the applicant remains the same, the inventor can get changed. Now, Ajay's role in this case would be restricted as an inventor only. This is crucial. You have to remember, because why I'm telling you this is it's at the end, a small thing is asked. Role of Ajay in this regard. That role of Ajay you have to mention specifically. There would be marks for that. Read every question carefully, what is asked basically. Now, herein, when I was discussing this question in one of my previous batches, that point of time, one of the questions raised was, sir, music is not allowed. Music is not patentable basically in the as per the Indian Patent Act, correct? But then in this case, of course, this is in the questions that I have framed are very raw. They are not up to the mark as per the probably the patent office standards. But then as far as section 3 of Indian Patent Act is concerned, still in that case, a music editing instrument or song editing instrument per se is definitely patentable, provided it is novel and is non-obvious, or it has certain inventive step involved in that. So this question gives you a broader idea about how to write the answers basically, how to write the answers. As I said, section now concept, the moment you whatever you write, but if you don't write patent of edition, you are going to lose crucial marks in that case. Second question I have is, Raj is a British citizen and Simran is an Indian citizen. They meet during the Europe tour and they work on a collaborative project to develop a concrete material which can be long lasting and really useful both for the Indian and European market. They want to file a patent in India and Europe now. They approach you. Provide advice to Raj and Simran about filing the patent in India and Europe and the steps involved therein as such. Now herein, there are two countries or a region, Europe and India is mentioned. This speaks about two things. One is the collaborative effort of an Indian scientist and a European scientist. Secondly, about filing the patent in two regions. One is India, the other one is Europe. One is India, the other one is Europe. And how it can be done? So herein, one concept that is relevant to this particular question basically is about the convention filing. Taking a priority of filing one application, let's say in India or Europe, and within 1 year, taking the priority of the first application, you can file in the other country as such. So convention filing is something which is important. Yeah. Now, also when you file outside India, as an Indian patent agent, you should be aware, if a client is filing the patent outside India without filing in India, you have to seek the FFL, that is foreign filing license, under section 39 form 25. You have to seek the foreign filing license as such. Or else, if you file, your convention application within 6 weeks. So there are two conditions under which FFL is required. First condition is if you file outside India directly, then FFL is required. And second condition is if you file in India, still within 6 weeks, if you are filing outside India, you would need a foreign filing license basically from the Indian Patent Office. So these two concepts are the ones which are very much relevant for the this particular question. Now you can mention about section numbers, you can mention about the inventorship, or both of them can be an inventor, or both of them can be applicants as such. You can mention about the different forms required for filing of a patent. But the most crucial thing herein is that you have to mention about two concepts. One is convention filing and foreign filing license. Now the question may be why convention and not the PCT route actually. You can also mention about the PCT route, like, to the client to file a application outside India, let's say, or like, but then if you mention it, you still have to provide the details of that. And practically speaking, when there are two countries mentioned, it is, of course, both the systems are allowed, the PCT as well as the Paris Convention Treaty, basically. But then for lesser number of countries, as we discussed earlier, for the lesser number of countries, the way is to have the convention route, basically. So class, this gives you a brief idea about the question. So it is, again, as I said, unless you know the concept, how they are coming from, how the sections are being interpreted, where are the concepts coming from, you may not be in a position to answer these kind of questions. Remember, again, you have to put it in the, I'm repeating this, you have to put it in the letter format to XYZ. Put the date. Don't reveal your identity at the end as a patent agent. Don't reveal your identity there. Put the date to the inventor's name, subject, and thereafter putting the, I would say, the details, including the concept. And when you are also telling to a client, remember that maybe in the both questions, actually, I would say, in case of this question in convention application as well as the patent of addition, you also have to inform them about the fees part. Whenever you are discussing about a client, a question is about a client, a patentee, basically, that point of time, because for patentees, from the patentee's perspective, even the I would say the fees matters. इसलिए आपको fees भी लिखना है वहां पे. Okay, generally for the individuals, you can mention any one fees as well. That would work well. The third question is now, and I would say these kind of questions are asked actually, and this is a direct question. Patlex is a startup in Latur in Maharashtra. Patlex is in the process of development of a hardware for easily accessing patent agent exam training contents. The prototype is ready. However, the final product would need 7 to 8 months to get developed. The hardware is novel, non-obvious. Patlex wishes to file a patent for an invention in India and PCT for the same. Patlex approached you for an advice on Indian and PCT filing. Advise them on various steps to be followed and schemes available for startup under Indian Patent Act. This is a direct question. This doesn't speak about the patentability, this is more of procedural. How to file an Indian application, how to file a PCT application, what forms are required, what fees is required actually. And that would be the answer to this particular question answer. So answering this kind of question again would so in, I would say, in first and second question, it was more about understanding the concept. If you understood the concept, bang on target. This kind of question and these kind of questions are also asked in the exam, which are direct procedural questions. Now, when I say direct procedural questions, it also mean that the if you have prepared well, in that case you can answer them really well. Remember, as far as the sessions of patent filing and prosecution are concerned, there is a higher probability of having these questions in paper 2 part 1 and viva. Paper 2 part 1 and viva, actually the patent filing and prosecution related questions. Another question, this is again a conceptual, this is a conceptual question that is, and you need to be very precise to understand what the question is speaking about. Now, Mr. Vijay filed a patent application in India on 19th October 2018, and without got it granted on 8th May 2019 without taking a help of a professional patent agent. On April 18th 2022, he realized that the patent is lapsed. Now the patent is lapsed. What now? Mr. Vijay wishes to maintain the patent, approaches you to seek the advice in this context. Kindly advise him the course of action along with relevant section numbers, forms, and fees. This is about a classic case. Of course, I think I don't know whether we have covered yet this in our live classes, but the recordings have this particular case, actually case as in the concept. Basically, this is about a concept called as restoration of the patent after the lapse. Restoration is allowed within 18 months after the lapse. Now, when did the patent get lapsed? When did the patent actually get lapsed? The patent gets lapsed and if you read this case very carefully, 19th October 2018, it was filed, got granted on 8th May 2019, and on April 18th 2022. So it's all about the timelines basically, because now herein as a concept, 2 years there is no renewal fees. 2 years there is no renewal fees. So 19th October 2018 to 19th October 2020, there is no renewal fees required. 19th October 2020 onwards, you would calculate 18 months, which would expire on 19th April 2022. 19th April 2022 tak, you can restore the patent because it is allowed within 18 months after the lapse. On 18th April, Vijay approaches you. Can you restore the patent? Firstly, the concept herein is a restoration. Can you restore as per the timelines? Yes, you can restore. What is required? The course of action actually, along with the section number, forms, fees. You put that form number, you put that fees, you put that section number per se for this. But one thing that is missing out probably is in the larger context. If you look at this case, Vijay filed this without help of a professional agent, and if he approaches you, then you have to get a power of attorney first. You have to get a power of attorney first, and then only you will have to put that restoration request to the Indian Patent Office. So you would need a power of attorney for the restoration of the patent. So this yahan pe, when you are writing the term restoration, the calculation of the timelines, and you just have one day, 18th April, 19th April, it would get it cannot be restored after 19th April actually. Right? So the concept of restoration, the timelines, the numbers, section numbers, the forms and fees is something which is required. Now, Juhi is developing a nutraceutical product to boost immunity. Anticipating objections relevant to section 3 DEIP, she approaches you for how can the rejections be avoided. Guide Ms. Juhi on the course of action required to overcome section 3 DEIP during the patent prosecution. Again, direct question, but you need to understand how to overcome, and exactly same question was asked in a different format. I would see if it was there. Yeah. Exactly same question was asked in a different format in the exam of 2022. How would you reply to an FER objection, section 3D, 3, 3I, 3P? Now, how to overcome these sections? That's what the understanding herein is required. Now, as far as section 3D is concerned, you have to use that term enhancement of therapeutic efficacy. Enhancement of therapeutic efficacy. If there is enhancement of therapeutic, see, section 3D doesn't bar the patentability of any product per se, but it bars the patentability if at all there is no enhancement of therapeutic efficacy. If there is no enhancement of therapeutic efficacy, then only it is not allowed. Now, the question herein is how to overcome. So herein actually, while answering, you have to mention that term enhancement of therapeutic efficacy. This word would have some marks associated with it for section 3D. Similarly, for 3E, the answer should include the word synergy. If there is a synergy, and remember that section 3E bars the patentability of combinations or multiple ingredients. Now, therein you have to mention to Juhi is that section 3E is applicable in cases wherein we have more than one ingredient being used in the nutraceutical product. Now, in that, if there are multiple ingredients used, then only section 3E is applicable. If there is a single active, there may not be any applicability of section 3E. If we are using more than 2 ingredients, they should have synergistic effect. That you need to mention. Third section, subsection 3I. In subsection 3I, it is essential to have, in subsection 3I, it is essential actually to have to avoid basically the term treatment. So the method of treating or a method of boosting immunity kind of claims are not allowed. That's what you have to actually mention. You have to avoid the term. So it is about the claim drafting in case of 3I. So the treatment options or prevention, uh, preventive options are not allowed under section 3I of Indian Patent Act. This information should go in your letter. Section 3P about the traditional knowledge. And let me tell you, I think this out of these four, 2 or 3 were included in that FER. In case of FER reply as well, you have to write like this. Okay, to overcome section 3D, like, to show the enhancement of therapeutic efficacy or show to the controller that this is not a new form of a known substance, basically. In case of 3P, the traditional knowledge, यहाँ पे आपको here and here to mention actually that the traditional knowledge per se cannot be patented. Traditional knowledge or any herb or anything from natural origin cannot be patented under section 3P. But an end product can be patented, but it should be not a I would say the traditional knowledge, or it should be actually a in a typical pharma language that we call it as, it should be something which is I would say a modern dosage form for the herbs. Okay, now question 6. On 20th April 2022, Mr. Ritik receives a hearing notice for patent application. The hearing is scheduled for 17th May. The objection raised is attention of the applicant is invited towards Section 6 of the Biodiversity Act, which mandates that if biological material obtained from India is used in the application for patent, then the permission and other information for making application for patent should be obtained from NBA, and details should be furnished in the application. Form 1, column 9(3). Kindly advise Ritik on various steps to be taken before appearing for the hearing and thereafter till the grant of the patent. Before I answer this question, class, once again, a request, if you have any questions, you can you can ask it in the chat box. I think I have got one question already from Shweta. Do we have to mention form numbers also in case of patent of addition? Yes, Shweta, you have to mention about the form numbers as well, actually. Okay, now coming back to this question now. This again is a procedural question. What happens at the time of hearing? Now herein, there are two separate things. One is about NBA and second is about the hearing and the further prosecution at the patent office. First part herein is, once you have got a hearing, you have to inform under Form 30 whether you are appearing for the hearing. Whether you are appearing for the hearing or who is appearing for the hearing, that you have to mention actually in the that particular answer. Second, once you attend the hearing, you have 15 days time to provide the written submissions. ये भी आपको mention करना पड़ेगा. Two things. These are happening at the patent office end. These are happening at the patent office end actually, right? Now, let us come back to the NBA's end now. Now at the NBA's end, you have to put the Form 3 of NBA. Form 3 of, not Indian Patent Act, Form 3 of NBA to file the request for NBA approval for the product. This receipt you have to submit to the patent office once you file that NBA. You can submit it during the written submissions as well. Now, generally it requires 90 days time for NBA to approve any kind of, I would say, NBA to approve any kind of IP application. That's written in the act actually. 90 days time. Within 90 days, they have to do that. Once you get that approval, you have to submit that approval to the Indian Patent Office via again Form 30. ये सारी चीजें वहां पे मेंशन होनी है. What things are there? This is a procedural part post hearing, and herein NBA is also included. So post hearing means you got a hearing notice. So you would, first thing you would do is that first thing you would do is inform the patent office through Form 30 that who would be attending the hearing. Second thing, attend the hearing. Third thing, after the hearing, within 15 days, you would provide the written submissions. And as far as the NBA is concerned, you would file Form 3 at NBA. You would file a Form 3 at NBA, and you get a receipt, acknowledgement receipt by NBA that you would submit under Form 30 to the Indian Patent Office. And later on, once you have complete approval from NBA, you would be in a position to, you have to provide that complete approval or that agreement basically to the Indian Patent Office. And accordingly, your NBA objection would be taken care of. So that's how you have to answer this. Conceptually very clear. Now, Mr. Suresh has filed a patent application having two separate products in the same invention. During the examination, he receives an objection in the FER that the claims of the complete spec relate to more than one invention. Advise Suresh on the course of action to be taken to reply to the FER. This is a classic case of a divisional application. This is about unity of invention. Now, this is a case of unity of the divisional application. You have to answer in terms of the divisional application only. So again, the same thing, section, forms, fees required, and remember that the divisional, in case of divisional application, you cannot add any data in the specification. You cannot add any data in the specification in case of a divisional application. This you have to mention. So based on the first specification for the parent, based on that only, you have to have a new claiming strategy. Also, in case of divisional as well as in case of patent of addition that we discussed in the earliest question, the important part is that the claims of parent and divisional have to be different. The claims of a parent and patent of addition have to be different completely. You can't have even a single claim common in that. It has to be different only. यहाँ पे again section numbers as well as the fees part and form numbers. For divisional application, again the same forms for filing of a patent, 1, 2, 3, 5, and if required 25. 1, 2, 3, 5 and 25. In case of divisional now, you have certain options left. First option is you surrender the second invention itself. Out of two, one option is you surrender the invention. Second, you file a complete or a divisional application for that. Remember that the divisional application has to be filed before the grant of the parent. before the grant of the patent. Patent of addition can be filed anytime during the lifetime of the first parent. Actually, I think this is sorry. This is eighth question. This is about opposition. Miss Jaya filed an opposition for patent which was filed by Rekha. So the Rekha has a patent, Jaya files opposition. Based on opposition, Rekha notifies the controller that Rekha notifies to the controller that she desires to withdraw the patent. Can Miss Rekha withdraw the patent when it's under opposition? Write down the relevant forms, fees, and section numbers. Also, Mr. Amitabh asked Jaya to ask if the cost incurred during the opposition can be recovered or not. Provide the relevant statute if Ms. Jaya can get the determination of cost under any conditions actually. So Jaya actually in this case can get the determination of cost. There is a concept called determination of cost actually. She can get that actually. Can Miss Rekha withdraw the patent? Yes, withdrawal of the patent is allowed actually. So withdrawal of the patent anytime is allowed as such. So this question is more on the determination of cost, and I believe just go through one of the videos at the end, 18th, 19th, 20th, jahan pe you would have the question 8 covered actually in that case, determination of cost. This is not a question of directly of opposition. This is about the withdrawal and the determination of cost as such. One more, and I think that's the last question that I have for today. I'll be sharing these. Of course, this video is available on the YouTube channel. You can go through these questions, try to answer them in your language, and get back to me with your answers as well. Now, Mr. Ranbir has filed an patent for agrochemical composition. Alia is an activist working for the rights of farmers. Alia files a pre-grant. Application gets granted. Now the question is, Miss Alia wants to file a post-grant. She approaches you for advice whether she can file a post-grant even if she was involved into pre-grant. Advice in this regard also suggests various steps involved into post-grant opposition. Can Miss Alia also file revocation if she has filed pre-grant and post-grant opposition? Answer herein is for this. Of course, you will have to mention about the opposition board, the post-grant opposition details, actually, the opposition board, who can be part of the opposition board, what I would say, what are the different steps and the timelines and the forms and the fees and everything. But there is no section which bars Alia. Why Alia? The question is, if she has filed a pre-grant, can she file a post-grant or revocation or all three? The difference herein, if you remember the session wherein we compared the pre-grant, post-grant and revocation, in that case, the pre-grant opposition can be filed by anyone. And for post-grant and revocation, it has to be by the person interested only. Now that person interested, whether Alia is a person interested or not, is the only key question here. Whether Alia is a person interested or not is the only key question here. And it is answered in the first paragraph, line number 2. Miss Alia is an activist working for the rights of farmers. That gives her a right to file, so she can be a person interested actually for a agrochemical product patent, agrochemical composition patent. So she is eligible to file a pre-grant because any person interested can. Post-grant and revocation as well. Sorry, pre-grant because anyone can file. Post-grant and revocation she can file because she can be considered as a person interested in this case. And there is no section or rule that bars filing of a post grant or revocation by the same party who has filed a provisional application. That means the answer to this is yes, she can. She can file actually the pre grant, post grant, and revocation. So, this, in a nutshell, what we have covered today are most of the questions which are related to patent prosecution, the procedural kind of questions. Once again, thank you so much for joining me on this Sunday for this session on answering to hypothetical questions, case studies, basically type questions in paper 2 of patent agent exam. I'm very glad for all those who joined for this session. This session is available on the YouTube channel. We would be having next session, which would be again an interesting session as such for all of you via YouTube live. By the month of this month, we would be having total 5 or 6 sessions. We have just covered 2. You can also go through our previous live session, which was on how 2023 patent agent exam would be different from uh, the previous year's question papers as such. This second session, I sign off with a simple hope that this was relevant and helpful for you for your preparation for the patent agent examination. I would definitely look forward for the feedback, especially from my students in the WhatsApp group, as well as would look forward to have you for the next live session very soon. Thank you so much and have a